Hey guys, welcome to my channel Grab Your Notes. This is Reshna sharing my handwritten notes. Today we are going to deal about the topic parties to suits. So let's get started. Hey guys, this is going to be a bit long video because this time I've made the notes in detail. So apart from law students, aspirants who try for other competitive exams can also use this. So good luck guys. So let's get into the topic. Order 1 of CPC deals with the topic parties to suit. The following 5 provisions are important under Order 1. Number 1. Who may be joined as plaintiff. Number 2. Who may be joined as defendants. Number 3. Representative suits. Number 4. Misjoinder, non-joinder and multifarious suits. And number 5. Miscellaneous provisions. So let's discuss our first topic in detail, that is, who may be joined as plaintiffs. Order 1, Rule 1 provides that all persons may be joined in one suit as plaintiff if any right of relief in respect of arising out of same act or transaction or series of act or transaction is alleged to exist in such person, whether jointly or severally or in the alternative. And if such person brought separate suit, any common question of law or fact would arise. For example, suppose A publishes a book bearing the title Oxford and Cambridge Publication, thereby creating an impression that it is a publication of the Oxford and Cambridge universities. Both the university may join as plaintiffs in one suit for an injunction to restrain from using the title as a publication, and the impression created thereby are the common question of fact arising out of the same transaction. This was actually a case. The case name was University of Oxford and Cambridge versus G. Gill and Sons. Rule 2 of Order 1 then provides that if it appears to the court that any joinder of plaintiff may embarrass or defy the trial of the suit, the court may put the plaintiff to their election or order separate trials or make such other orders as it may deem expedient. Then Rule 4 says that if several persons are joined together as defendants and it is found that only some of them are liable, a judgment may be given against such persons only without any amendment of the proceedings. And our second topic was who may be joined as defendants. Rule 3 of Order 1, which deals with the joinder of defendants, provides that all persons may be joined in one suit as defendants if any right to relief in respect of or arising out of the same act or transaction or series of act or transaction is alleged to exist against such persons, whether jointly or severally or in the alternative. And if separate suits were brought against such persons, any common question of law or fact would arise. If two or more persons are joined as defendants in one suit, in a case where foresaid two conditions do not exist, the result would be a misjoinder of defendants. Let's discuss a case regarding it, that is Belair versus LGO Company 1907. In this case, B, while riding in an omnibus belonging to L, was injured as a result of the collision between the bus and a car which was belonging to C. B sued L and C for damages for personal injury, charging the defendants jointly with joint negligence and alternatively with separate negligence against each of them. In these circumstances, the court held that the suit was not bad for misjoinder of defendants, as the injury to the plaintiff arose from the same transaction and it involved a common question of fact. Rule 3A of Order 1 then provides that if it appears to the court that any jointer of defendants may embarrass or delay the trial of the suit, the court may order separate trials or make such other order as may be expedient in the interest of justice. Rule 4 provides if several persons are joined together as defendants and it is found that only some of them are liable, a judgment may be given against such person only without any amendments of the proceedings. Rule 5 says when there are more defendants than one, it is not necessary that every defendant should be interested in all the relief claims in the suit. Rule number 6 provides in cases of suits on contracts, it is specifically provided that the plaintiff may, at his option, join as parties to the same suit all or any of the persons severally or jointly and severally liable on any one contract, including parties to bill of exchange, hundies and promissory notes. Rule 7 then provides that if the plaintiff is in doubt as to the person for whom he is entitled to obtain redress, he may join two or more defendants in order that the question as to which of the defendant is liable and to what extent may be determined as between all the parties. Our next topic of discussion is representative suits, which is dealt under Order 1, Rule number 8. Rule 8 of Order 1 provides that where there are numerous persons having the same interest in one suit, one or more of such persons may, with the permission of the court, sue or be sued or may defend such suit on behalf of or for the benefit of all the persons so interested. Also, this rule says the court may direct that one or more such persons may sue or be sued or may defend such suit on behalf of or for the benefit of all the persons so interested. When such permission or direction is given, the court must at the plaintiff's expense give notice of the institution of the suit to all persons so interested either by personal service or where by the reason of the number of persons or any other cause such service is not reasonable by public advertisement as the court in each case may direct. Notice in the manner specified above and must be given by the court to all persons so interested before any part of the claim in any such suit is abandoned, before such suit is withdrawn, before any compromise or agreement is recorded in any such suits. If in any suit, person suing or defending does not proceed with due diligence, the court can substitute in his place any other person having the same interest in the suit. It is to be noted that any decree passed in such a suit is binding on all persons on whose behalf or for whose benefit the suit is instituted or defended as the case may be. Now let's discuss what is representative suit. A suit filed by one or more persons under this rule on behalf of themselves or others having the same interest in the suit is called a representative suit. The provisions of explanation 6 to section 11, which deals about res judicata, applies to such a suit. But if the suit is won under Order 1, Rule 8, the provision of that rule must be strictly complied with. Now let us know what are the conditions for representative suits. In order that Rule 8 may apply, the following 4 conditions must be satisfied. Number 1, the parties must be numerous. Number 2, they must have the same interest in the suit. The interest need not be a proprietary one, but an interest merely as a member of the public is not sufficient interest for the purpose of this rule. Number 3, the court's permission under the rule must be obtained. Number 4, notice must be given to the parties whom it is proposed to represent in the suit. Now let's get into the object of the rule. This rule is an exception to the general rule that all persons interested in a suit ought to be made parties thereto. Convenience requires that in suits where there is a community of interest among a large number of persons, a few should be allowed to represent the whole so that the trouble and expense may be saved. And regarding title of suit, where a suit is brought by or against persons in representative capacity, the fact should be stated not only in the plaint but also in the title of the suit. Now our next topic is misjoinder, non-joinder and multifarious suits. Rule 9 of Order 1 provides that no suit is liable to be defeated by reason of misjoinder or non-joinder of parties. In such cases, the court may deal with the matter in controversy as regards the rights and interest of the parties actually before it. However, this rule does not apply to cases where there is a non-joinder of a necessary party. We'll be dealing about what is necessary party in this video itself. Now let us know what is misjoinder. The joinder of any person as a party to suit contrary to the provision of the court is called misjoinder. Misjoinder may be of 3 kinds. Number 1, misjoinder of plaintiff. Number 2, misjoinder of defendants. Number 3, misjoinder of causes of action. Let us know each topic in detail. Misjoinder of plaintiff. Where there are more plaintiffs than one, the provision of Rule 1 may apply. It provides in effect that 2 or more persons may be joined as plaintiff in one suit. If the right to relief alleged to exist in each plaintiff arises from the same act or transaction, and there is a common question of law or fact, and if 2 or more persons are joined as plaintiff in one suit in a case not covered under Order 1, Rule 1, the result is a misjoinder of plaintiff. Now let us know what is misjoinder of defendants. When there are more defendants than one, the provisions of Rule 3 of this order may apply. This rule provides that 2 or more persons may be joined as defendants in one suit if the right to relief alleged to exist against each of them arises from the same act or transaction and there is a common question of law or fact. And if two or more persons are joined as defendants in one suit not covered by Order 1 Rule 3, the result is a misjoinder of defendants. Now let us know what is misjoinder of causes of action. A misjoinder of causes of action may be coupled with a misjoinder of plaintiff, or it may be coupled with a misjoinder of defendants. Now let us know what is multifariousness or multifarious suits. Where in a suit there are two or more defendants and two or more causes of action, the suit will be bad for misjoinder of defendants and causes of action. If different causes of action are joined against different defendants separately, such a misjoinder is technically called multifariousness. Under Order 2, Rule 7, all objections to the effect that the suit is multifarious must be taken at the earliest possible opportunity, and in all cases where issues are settled at or before such settlement, unless, of course, the ground of objection has arisen subsequently. If such objection is not so taken, it will be deemed to have been waived. Now let us know what is a non-joinder. Where a person who is a necessary party to suit is not joined as a party to the suit, the case is one of non-joinder. A suit should not be dismissed on the ground of non-joinder. The objection on this ground should be taken before the first hearing. This has been provided under Order 1, Rule 13, and the plaint may be amended by addition of the omitted party either as plaintiff or as defendant. Bearing in mind that no person can be added as plaintiff without his consent, though he may be added as defendant without his consent. Rule 13 then provides that all objection as to non-joinder or misjoinder of parties must be taken at the earliest possible opportunity and before the settlement of issues, and any objections not so taken is to be deemed to have been waived. We have already mentioned the term necessary parties in this video before. Now let us know who are necessary parties and who are proper parties. Necessary parties are those parties who ought to have been joined in a suit. That is, party necessary to the constitution of the suit, without whom no degrees can be passed at all. Proper parties, on the other hand, are those parties whose presence enables the court to adjudicate the matter more effectively and completely. In the case of Nyaya Catholic Congress versus Baiju Udup 1990, court held that for an effectual and complete adjudication of questions arising in a suit, a third party would be added by the court if he is a proper party, although he may not be a necessary party to the suit. There are a lot of other miscellaneous provisions in Order 1 which deals with the topic parties to suits. So let's get into that. Order 1 contains other miscellaneous provisions as regards to parties to suit, which may be summarized as under. Number 1. While trying a suit, the court may allow a person or body of persons to present his or its opinion and take such part in the suit proceedings as the court may specify. And if the court is satisfied that such a person or body of persons is interested in any question of law which is directly and substantially in issue in the suit, and that is necessary to do so in the public interest, which has been provided under Rule 8A. Number 2. if the suit is instituted in the name of a wrong person as the plaintiff, or if it is doubtful that if the suit is instituted in the name of the right person, the court may allow any other persons to be substituted or added as plaintiff if it is shown that there was a bona fide mistake. This has been provided under Rule 10, Sub-Rule 1. Number 3. At any stage of the suit, the court may order that the name of any party who is improperly joined be struck out and the name of any person who ought to have been joined be added to the suit. This has been provided under Rule 10, Sub-Rule 2. Number 4. If the defendant is added unless the court otherwise directs, the plaint must be amended, and the amended copy of the plaint and summons must be served on the new defendant, and if the court deems fit, also on the original defendant. This has been provided under Rule 10, Sub-Rule 4. In this connection, it should be remembered that the Limitation Act provides that when, after the institution of a suit, a party is added as a plaintiff or a defendant, the date of addition is to be considered as regards that party as the date of institution of the suit. It has been held that where necessary parties are not joined within the period of limitation, the suit must be dismissed. Number 5. The court is also empowered to request any pleader to address it as to any interest which is likely to be affected by its decision on any matter in issue in any suit or proceedings, if the party having the interest which is likely to be so affected is not represented by any pleader. And the last miscellaneous provision, number 6. The court may give the conduct of a suit to such persons as it may deem proper, which has been provided under Rule 11, where there are more plaintiffs than one. Any one or more of them may be authorized in writing by the others to appear, plead, or act for such other parties in any proceedings. The same rule applies in a case where there are more defendants than one, which has been provided under Rule 12. That's all for today. Let's continue in the next video. Happy learning, guys!